All right, we are here in case 26 CR 546. We're present for a pretrial. State of Ohio is present, represented by Assistant Prosecuting Attorney Rocco DePiro. Defendant is here in open court with counsel Mr. James Matthews. Excuse me. Mr. DePiro, what's this? Can you give me a brief summary of what this case is all about?
Yes, Your Honor. Painesville police were called on April 14th about 10:30 in the morning for a male that was flailing his arms and just kind of disturbing people over near the Chester Food Mart in Atwell's parking lot. Officer Elizabeth Fowler responded, found the defendant here doing that, walking around the parking lot waving his arms. Officer asked him what's going on. He said he's having a great day. Kept reaching for his right side. Officer told him to stop. He wouldn't. And officer grabbed him, and then he and another officer responded, and then he fought his way away from those police officers, ran to a nearby backyard, was tased, and through the course of it, Officer Fowler got some abrasions.
Got what?
Abrasions. And the defendant had a syringe in his right pocket. It had cocaine and methamphetamine in it. Residue. And that's it, Judge.
Okay. Discovery's been provided?
Yes, Your Honor.
Is there an offer that the state's prepared to make?
Yes, Your Honor. The defendant would plead guilty to count 1 and count 2. It's an F5 obstructing official business, and count 2 being F5 ag possession of drugs being meth. State would dismiss count 3, the possession of cocaine. State would review the pre-sentence report prior to sentencing, can recommend any sentence. The defendant also can recommend any sentence that he wants. I expect the defendant's going to ask for community control. The defendant agreed to voluntarily forfeit the drugs in the syringe. Thank you.
Thank you. Give me a brief just summary of history, defense history.
Yes, Your Honor. The defendant's 36 years old. He has 1 prior felony conviction from 2014. It's an F5 forgery. And
that was with me, wasn't it?
Yes, Your Honor.
Okay.
And F5 identity fraud. He was on community control, ultimately went to prison for 10 months. He has a number of
misdemeanors. On a violation?
On a violation.
Okay.
Yeah. That's his only felony. He has a number of misdemeanors, including in February of 2026, a misdemeanor petty theft and a misdemeanor obstructing official business, Mentor Municipal Court, that he was on probation for at the time he committed this offense. June 2025, he had a misdemeanor theft and an M4 trespassing, and all the misdemeanors are before that, if you want me to go through it.
Yeah.
Okay.
The June of 25 one, was he on probation for that when this happened?
I don't know. I'll have to find that out, Judge.
All right, thank you.
Thank you.
Mr. Matthews, you receive all the discovery?
If it's been provided, I would assume so.
Any, I mean, you've gotten stuff, and I guess you don't know if it's everything. You've been given discovery from the state. Okay. Any suppression issues on this case?
None that I know.
Anything else you'd like to add at this point?
No.
All right, well, our trial is scheduled for July 7th, so the court will need to know by June 23rd whether the defendant is going to accept the state's offer or if he's going to go to trial. Well, I guess we don't have to know if he's going to go to trial. We just have to know if he's going to accept the offer. If we don't hear anything, then we assume he'll be going to trial or he'll have to plead the indictment. So you understand that, Mr. Sidoti?
Yes, sir.
Okay. All right, now we're also here on I'm going to file this as a motion, or maybe it's already been filed as a motion. I received a letter from the defendant, which he's requesting that he have a different public defender appointed for him. The court is going to cause this motion to be filed, or this letter to be filed and treated as a motion. So I'll let you be heard on this request, Mr. Sidoti. Why do you believe you're entitled to have another public defender appointed for you?
I just felt that he wasn't invested in me, like, 'cause he's got a lot going on. And another guy that I talked to, I felt like was more invested. His name was Chad Mulkey. I just felt like he gave me better advice. I don't know. That's just how I felt. I can't really, like, I just felt he was very brief and short. The other guy explained everything in more detail to me. Do you know what I'm saying?
Just giving you a chance to explain why you believe you're entitled to have another lawyer appointed for you. So that's the basis for this?
Yeah.
Well, you have the right to have an attorney appointed for you when you cannot afford an attorney, and the court has done that. You do not have a right to pick and choose who your lawyer is going to be. Mr. Matthews has been at this a long, long time. He's been doing this, how many years now, Mr. Matthews?
Going on 26.
26 years. He's handled all types of cases. He's very good at what he does, very experienced. And there's nothing that you have set forth to the court which would cause this court to believe he's not doing the job the way he's supposed to do it. So your request for a different public defender to be appointed is denied. Again, the court's going to need to know by June 23rd whether this is going to be a plea or if you're going to accept the state's offer. So you're going to need to communicate with your lawyer, Mr. Matthews, about that. Do you have any questions for me?
Nope.
Mr. Matthews, anything for the record you'd like to add?
No, Your Honor, thank you.
Mr. DePiro, anything else?
Yes. I would like to say that Mr. Matthews called me prior to this case going to the indictment to inquire about this case, to ask for discovery, and to see if we could work on a resolution. And this was in the very beginning of the case. And that doesn't always happen.
Yeah, that would have to be end of April, beginning of May.
I don't remember the exact date, but that sounds about right. So I think I need to stand up and say that, because not every attorney does that. Mr. Matthews did do that in this case. He called me and he asked about it. He wanted the discovery. He wanted to talk to me before the case even got off the ground.
All right, thank you.
Thank you.
All right, that's all, thanks.
All rise.
You guys can go, I'm going to stick it for
We are here today in the state of Ohio versus Michael Cooper Habit, case number 25CR 1541. The defendant is present with counsel Matthew Ziccarelli, and we're here today for a sentencing hearing. We were last before you on April 20th for a change of plea. During that hearing, the defendant pled guilty to count 1, aggravated possession of drugs, a felony of the 5th degree, with an attached forfeiture specification. During that hearing, a pre-sentence report and drug and alcohol evaluation were ordered. Those reports have since been completed, and the defendant has 9 days of jail time credit. Thank you.
How much credit did you say?
9 days.
One second, please. Mr. Ziccarelli, any reason not to go forward with sentencing?
No, Your Honor.
Anything you want to say on behalf of your client?
Yes, Your Honor. I think that a lot of the material in the pre-sentence report speaks on what my client has going for him. He has an 83-year-old grandfather that he currently takes care of, lives with him, and is the only one that's been available to take care of his grandfather. My client does have a high school diploma. He's local from the area, from North High School. He graduated in 2010. He has an 8-year-old son that he's involved in his life. He does not have custody or any sort of official orders, but he does have a relationship with him and does see him. He also is receiving medically assisted treatment right now from Signature Health. I know speaking with him, reviewing the PSR, that treatment has been beneficial for him. Through that, they've been providing him with Sublocade injections that has significantly helped my client with his addiction issue. My client also has been, he received 2 drug tests from the probation department, and all those drug tests were negative. I believe if he were to be tested today, it would also show up negative for any non-prescription medications. The PSR does reflect the history that my client has. I think looking at that, he has an extensive problem with drug usage. He does not have any violent offenses on his record. He is 33 years old, and I think for the majority of his life, since he's been a teenager, he's been dealing with some addiction problems. I think that's the root cause of his misdemeanors and his behavior. I think that any sort of treatment would be beneficial for him. I do think that reviewing the drug and alcohol evaluation, yes, you know, he was reserved, did say in there that he did not need to receive any sort of treatment, that he did not think it would be useful for him. I know speaking with him today, I don't believe that is his mindset. I believe that he understands and is asking this court to issue an order that he receive treatment. I think that he is looking to take advantage of orders from this court to help him get the help that he needs to overcome these addiction issues. I mean, he's been using numerous drugs, serious drugs, for the majority of his life, and I think that it's something he wants to put behind him and get in control of. I think that under revised code 292912, some of the factors that this court considers, no harm was committed to any property or to another person. The only harm was done to himself. He does show genuine remorse. I think when you hear from him speaking here today, you'll hear remorse from him. I know that since I have been representing him on this, he has indicated to me that it's a problem. He understands it's a problem, and he is not only apologetic to this court, but mainly to himself that he has a problem and is sick. So, Your Honor, I think as well, reviewing the drug and alcohol evaluation, the recommendations on there, I know they're not necessarily recommendations on whether a prison term should be imposed, but if this court imposes community control sanctions, I think that those recommendations would all be appropriate. I would also ask that this court allow him to take advantage of orders, allow him to be the one that makes any mistakes if he is to violate any orders of this court, and let him get the treatment that he needs. I would also ask, Your Honor, if this court is going to impose any sort of license suspension, that they do not do that, as he is looking to continue driving so that he can get the help for his grandfather. Your Honor, once again, I would just ask the court to consider ordering treatment for my client and suspend any sort of prison term. Thank you.
Excuse me. Well, Mr. Cooper Habit, you have the right to address this court before your sentence. You can say anything you want. Is there anything you want to say at this time?
Yes, Your Honor. I just wanted to apologize if there was miscommunication on the PSI about me not wanting treatment. I do want treatment.
Well, there was no miscommunication. How is there miscommunication? You flat out said you don't need it. That's not miscommunication.
No, I do want treatment. I do want treatment. Yes.
Go ahead. I'm sorry.
No, I do want treatment, and I am just, I'm just looking to continue bettering my life. I've been sober for quite some time now, and that's really all I gotta say. Thank you.
I mean, when you talk to the people at the woman doing the drug and alcohol evaluation, you quote said, "I don't need any treatment except for someone to keep giving my meds. I'm fine the way I am." That's not miscommunication. Those were your words, word for word.
I believe it was Lake Geauga that interviewed me. Is it Lake Geauga?
Yeah, she's a woman from Lake Geauga.
It is Lake Geauga Center.
Well, you met with her at the sheriff's department.
Yeah, I'm going to Signature Health, and that's who I'm in treatment with. Signature Health in Willoughby.
You're in treatment with Signature Health.
Yeah, I'm in the MAT program at Signature Health.
But you get the shot. But you claim that you finished an IOP. You never finished an IOP.
No, I'm in individual counseling at Signature Health in Willoughby.
I understand. So I guess I don't get it. I don't need any treatment except for someone to just keep giving me.
No, I apologize for saying that.
Mr. Zuccarelli, anything else on behalf of the defendant?
Nothing further, Your Honor, other than just to emphasize that through Signature, since he's began taking these Sublocade injections, they've been very beneficial to him.
Ms. Bell for the state.
Thank you, Your Honor. The state had the opportunity to review the pre-sentence report and drug and alcohol evaluation in this case. The state has several concerns. The defendant has a lengthy criminal history, 20 separate cases as an adult. He's been to prison, 2 different prison numbers. He also picked up a new case while out on bond on this case. Based on all of that, the state cannot recommend that he's a good candidate for community control and would recommend prison. Thank you.
Well, the court reviewed the pre-sentence report and investigation, the drug and alcohol evaluation, have considered the facts and circumstances of the offense involved, the nature of the offense involved. Consider what's been said here in court. All this is considered in light of the purposes and principles of felony sentencing set forth in 29-29-11. For the factors in 29-29-12, nothing stands out factually indicating the conduct is more or less serious. As for recidivism factors, almost all of these factors are present. Then it has a lengthy history. It goes back 19 years as a juvenile, starting when he was 15 years old. Then continues on as an adult. He's been on community control before and probation before multiple times and has violated multiple times. He's been sent to prison before because he's not been able to comply with conditions of previously imposed sanctions. This factor indicating recidivism is more likely. There's a drug abuse problem that relates to the offense, and he denies that. He denied that every opportunity he had with the probation department when he met with them. First of all, denies he even committed this offense. He says he was just sleeping in the car when they showed up there, that he was completely unresponsive when they attempted to rouse him up multiple times. He then denied committing this offense to the probation department. There's a drug abuse problem that relates to the offense, and again, he denies there's an issue there. We met with the drug and alcohol evaluation. Miss Friend from Lake Geauga for the interview. She started asking him questions, and his response was, quote, "I just answered all these same questions. Why don't you guys call up there and get the answers? Don't you guys communicate?" End quote. She explained that they were questions that were to provide me, as the judge, with an accurate account of his mental health and substance use history. If he chose not to answer, she would advise me of that. He agreed to cooperate, but was very irritable and disrespectful when responding, provided minimal information. He then told her at some point, "I don't need any treatment except for someone to keep giving me my meds. And I told you when you were here, you're going to meet with them. It was important to be open and honest with them when you met with them, because they're going to let me know everything. They're going to check on everything that you tell them. And I'm going to consider that." You were told that. The prognosis with Ms. Friend from Lake Geauga is guarded due to his behaviors during the evaluation and statement that he does not need any treatment. Again, he denied even being involved in committing the offense, but said felt he had to plea. He committed a new offense after he committed this offense. While he was on bond in this court, he committed an offense in Euclid. Another drug offense. But he claims he doesn't have a problem until he's here today. No factors indicate recidivism is less likely. Under 2929-13b1, court finds defendant pre-prison term. Prison is consistent with the purposes and principles of sentencing. And there's just no way this court can make the findings amenable to community control sanctions. He doesn't want to be on probation. Well, he wants to be on probation because he doesn't want to go to prison. But he doesn't want to deal with what's necessary to, he's been through every treatment program there is already. He can, quote, write the book, as he said. But he just continues to engage in this conduct. He's not amenable to community control sanctions. Therefore, it will be the sentence of this court. And count one, defendant served a term in prison of 8 months. He has credit for 9 days he served. Count two will be dismissed. I need to advise you upon your release, you could be put on post-release control for up to 2 years. If you are and you violate any of those conditions, the parole authority could send you back to prison as punishment for violating their rules for another 4 months, the maximum being 50% of the prison term I just imposed. Any additional prison term imposed for violating post-release control is being imposed as part of the sentence at this time. Court disapproves the defendant's placement in a program of shock incarceration, intensive prison program, or transfer to transitional control. Order the forfeiture of the contraband and instrumentalities. Bond will be released. I'm not going to order a driver's license suspension or a fine. Ms. Bell, is there anything else for the record?
Nothing further, Your Honor. Thank you.
Mr. Ziccarelli.
No, Your Honor.
morning, Your Honor. We are hearing case 26-CR-273, State of Ohio versus Colleen M. Kelly. Present in court is the defendant, who's accompanied by her attorney, Ms. Nicolette Tomaszek. We are here today for a pretrial on a 4-count indictment that was filed April 27th, 2026. It is for 2 counts of possession of cocaine, both of which are felonies of the 5th degree, 1 count possession of dangerous drugs, a felony of the 5th degree, and then 1 count illegal conveyance of drugs of abuse onto the grounds of a specified government facility, a felony of the 3rd degree. The state has provided discovery to the defense and has made a written plea offer in this case, and that would be that the defendant would plead guilty to count 1, possession of cocaine, a felony of the 5th degree, as well as count 4, illegal conveyance of drugs of abuse onto the grounds of a specified governmental facility, a felony of the 3rd degree. The state would dismiss the remaining counts of the indictment at the time of sentencing, and the state would request a pre-sentence investigation and report, as well as a drug and alcohol evaluation before making any sentencing recommendation.
Okay, thank you. Just briefly, can you summarize factually what happened here?
Sure. On January 19th, 2026, the Painesville Police Department were dispatched to 117 Mentor Avenue in the city of Painesville, Lake County, Ohio, for a reported assault. They located the defendant leaving the apartment building at that location. She had previously been trespassed from that location. She did consent to a search of her person and belongings. There was nothing located on her person. However, when searching her belongings, officers found a needle as well as a chore boy and crystal-like substance consistent with narcotics folded into paper. They also located a prescription bottle with the name of a 3rd person, not the defendant, on it, and that bottle was for pills that were levetiracetam, a dangerous drug. And then after the defendant was transported to the Lake County Jail, when she was being changed into jail clothes, officers located a 3-inch clear glass pipe that was hidden inside her bra, and that had a burnt chore boy inside with residue.
Thank you.
You're welcome.
I was not trespassed until after that.
All right. Ms. Thomas, anything you'd like to add at this point? You received the discovery?
Yes, Your Honor, we received discovery. I did receive the offer, and I have relayed that offer to Ms. Kelly.
Okay.
Yep.
Any suppression issues here in this case?
No suppression issues.
Anything else you'd like to discuss, or well, yeah, you don't need to? I just want to make sure you get a chance.
Nothing additional at this time, Your Honor. Thank you.
All right. Well, our trial in this matter is set for July 14th. Ms. Kelly, you've been released on an own recognizance bond, which means you need to appear at all future court dates. That is the next court date, at least at this point, July 14th, your trial. If you fail to appear at any future court dates, that's a separate felony you can be prosecuted for. It's a felony of 4th degree, so it's an additional 18 months you can receive in addition to whatever happens on these charges. So it's obviously important you show up at all future court dates. Now, the trial is July 14th. If you decide, and you don't need to let me know that now, if you're going to accept the state's offer, we need to be advised of that by your lawyer by July 1st. Right, make sure that's right. June 30th. June 30th. So you'll need to make sure that you let your lawyer know by June 30th whether you want to accept the state's offer and enter a plea to these charges, or if not, then we're going to go to trial. If we don't hear from your lawyer by June 30th, then it's either going to be a trial or you're going to have to plead to the entire indictment. So it's important that you keep in touch with her, communicate with her to discuss this, to decide what you want to do. Now, if you are going to accept the state's offer and enter a plea, that hearing will be before July 14th.
Okay.
So then So your next hearing date will be before July 14th. Obviously, though, I don't know that now because I don't know what your intentions are, and you don't need to tell me that now. But I want to make sure you understand that if you decide you're going to enter a plea, it will be before July 14th. So I presume you'll talk with your lawyer, you'll come to some consensus on one way or the other. If you do decide it's going to be a plea, I need to make sure you understand that a different date will be set before that. So that you need to make sure you find that out. Your lawyer will notify you of that, but if for whatever reason you don't hear from her, you don't get the notice, the ultimate responsibility is still on you to find out when that date is. So if you don't hear from them, you contact them, you can contact the court, you can go online and look, but you need to find out when that date is because it's your responsibility to be there for that at that time, okay?
Okay.
All right. All right, I think that covers everything. Ms. Himmeline, anything else for the state?
No, Your Honor, thank you.
Ms. Tomaszek?
No, Your Honor, thank you.
All right, thank you all.
All rise.
All right, we're present in case 26 CR 241, State of Ohio versus Parker Koval. Is that how you pronounce it, Koval?
Yes, Your Honor.
We're here for a hearing on the defendant's motion for intervention in lieu of conviction. Defendant being charged by way of information with one count of improperly handling no indictment here? What's information? With improperly handling firearms in a motor vehicle, a felony of the 5th degree. Subsequent to the filing of that information, again, the defendant filed a motion for intervention in lieu. As a result, the court referred the defendant for an assessment pursuant to 2951.041. That has been completed. Copies have been made available to both sides. And again, we're present for the hearing on that motion. Defendant's in court. It's with the counsel, Mr. James Reardon. And the state of Ohio is represented by Prosecutor James Flays. All right, Mr. Reardon, would you like to be heard on your motion?
Yes, thank you, Your Honor. For the record, I did have an opportunity to review the assessment report prepared by the court's assessor. In reading it, she goes through all the elements of intervention, and per the report, she is indicating that Mr. Koval is eligible to be referred to intervention in lieu of conviction. I think clearly, based on the substance of the report, that it is Mr. Koval's substance abuse, addiction, problems, issues, clearly are the nexus to the criminal behavior. So I think that's the key thing to consider here. I also believe that given Mr. Koval's prior criminal record proceedings, that it also further drives home the point that Mr. Koval needs treatment. And as the court is aware, in addition to a reasonably lengthy stay in jail, he's also been inpatient at Wellbrook for the last almost 60 days. So he has taken this matter seriously. He has taken steps on his own to address the problem, and it is my hope that the court sees it the same way as I do and the assessor does, and that the court grants his motion and allows him to participate in the intervention program. Thank you.
Thank you. Mr. Flays, does the state have a position on the defendant's motion?
Thank you, Your Honor. The state has discussed this matter with Mr. Reardon and has reviewed the defendant's criminal history and obviously the details of this offense, and believes that the court granting intervention in lieu of conviction would be the appropriate course here. He does have a pretty consistent history, and that history of abuse has landed him in trouble in the criminal courts, and the state feels that the type of program at the common pleas level, with the potential sanctions that he'd be facing if there are further violations, would be a good way to handle this case at this time. And the state would note, and Mr. Reardon touched on this, the defendant has, and much by his own choosing, has been either incarcerated or in inpatient treatment since the date of arrest on February 14th. So I think before we've gotten to this point today, he's shown both the state of Ohio and I think the court that he's willing to commit to sobriety and treatment. And I think that should weigh heavily on the court's decision. Thank you.
Thank you. Now, well, the court has reviewed the assessment that was prepared, again, in relation to the referral the court made. I've considered the pre-sentence investigation that was also completed at that time. I've considered the arguments of counsel, positions of each party, and in considering the foregoing, the court finds the defendant is eligible for intervention in lieu of conviction pursuant to 2951.041B. It's the court's intention to grant that motion. Now, before I could actually officially grant it, Mr. Koval, I need to make sure you need to plead guilty to the charges. And before I can accept your guilty plea, I need to make sure you understand everything we're doing here, which means I need to make sure you understand what your rights are that you give up by pleading guilty. And I also need to be assured you understand the potential penalties you could face. Now, with intervention of conviction, I'm sure your lawyer has explained it to you, but I'll do it as well. You're required to plead guilty to the charge and the information. If the court accepts your plea, I will at that point grant the motion and order a stay of all future criminal proceedings. That means everything is put on a pause at that time, which includes finding you guilty and also includes sentencing. I then put you under the supervision of the probation department for a period of time with an intervention plan that will be ordered. You comply with that intervention plan, the rules of probation for a period of time. If you do that successfully, at the end of that period of time, the case gets dismissed. And you no longer have that you won't have that on your record. Not that you no longer, it's not in your record yet, you haven't been convicted. But this case, this felony conviction, would not be on your record. Now, I know you've got a couple other convictions, but none of them are felonies. And not having a felony conviction is a pretty big deal. So this is a pretty extraordinary request that is being made, and I'm okay with it. But you only get one chance at it.
I understand.
If you violate, you may be put on probation. You may not go to prison. You could go to prison, but you may not go to prison, but you're going to have that conviction then. So you only get one chance at that. You understand that?
Yes.
All right. Point is that I need to make sure you understand the potential penalties you could face if you did violate. Again, it's no one hopes that no one wants you to do that, and I wouldn't be granting it if I thought that was what's going to happen. But if you were to violate the plan, we would come back here to court. I'd vacate the stay. We proceed with sentencing. You'd be found guilty. We proceed with sentencing. So I need to make sure you understand those potential penalties you could face if we ever got to that point. So I'm going to review that with you as well. If you have any questions at any point, make sure you ask. If you want a moment to talk with your lawyer, let me know that, and I'll let you speak with him. If you need anything repeated or clarified, make sure you let me know that, all right?
Okay, thank you.
Let's get started then. How old are you, sir?
23.
23?
Yes, sir.
Are you able to read and write the English language?
Yes.
Do you have any difficulty with that or difficulty understanding what you read in the English language?
No.
Are you a U.S. citizen?
Yes.
Now, before you came into court here this morning, have you any drugs or alcohol of any kind?
No.
What about in the last 48 hours?
No.
Not even prescribed medication, nothing?
The only prescribed medication I took is hydroxyzine.
When would you have last taken that?
Would have been yesterday.
Okay. Does that medication in any way affect your ability to understand or appreciate where you are, what's going on around you, or anything like that?
No, Your Honor.
All right. Now, did you receive a copy of the information that was filed in this case? That's the document that sets forth the specific charge you're accused of committing?
Yes, Your Honor.
And did you have a chance to go over that at some point?
Yes.
Now, in that information, you are charged with one count, and what's alleged here and what you'll be admitting to is on or about February 14th, 2026 in Willoughby Lake County, Ohio, that you did knowingly transport or have a loaded handgun in a motor vehicle, and at the time of that transportation or possession, you were under the influence of alcohol, a drug of abuse, or a combination of them. That conduct constitutes the offense of improperly handling firearms in a motor vehicle. It's a felony of the 5th degree. Do you understand what you're charged with and pleading guilty to in this information?
Yes, Your Honor.
Any questions for me about it?
No, Your Honor.
Well, then before I can accept your plea, I need to make sure you understand all the rights you are giving up. And you first of all have the right to have this case presented to a grand jury. So that document I just read to you is called an information, and information is a criminal charge brought by the prosecutor's office, the state of Ohio, without the case having previously been reviewed or considered by a grand jury. Now, what a grand jury is, it's made up of a group of citizens here from Lake County that get together and they meet privately. They meet in secret for the purpose of evaluating evidence in cases to determine whether probable cause exists that someone committed a crime. We define probable cause as some evidence that would suggest a person probably committed a criminal offense. Now, everybody here in the state of Ohio accused of a felony has the right to have a grand jury independently review the evidence in a case and make a decision without the government being involved in that decision, whether someone should be charged or not. You have that right as well. But you can give up that right if you desire and go forward on the charge brought by the prosecutor in this information. And your lawyer has indicated he believes that's how you want to proceed. Is that right?
Yes, Your Honor.
Well, before I can go any further, I need to have you acknowledge that here in open court in writing. I have in my possession at this point a one-page document called a waiver of indictment, which sets forth what I just explained to you about that grand jury process, and that you want to give up that right. Before I can go any further, I need to be assured you understand that document, that you signed it here in open court. Now, my understanding is before I walked out here, you had a chance to go over that with Mr. Reardon. Is that correct?
Yes, Your Honor.
Mr. Reardon, is that accurate? Did you read this over with your client, review it with him, answer his questions?
I did, Your Honor.
Did he indicate an understanding of it to you when you did that?
Yes, he did.
Is that correct, Mr. Coble?
Yes, Your Honor.
So you understand what that document says?
Yes.
You have any questions for me about it?
Not at the time, no.
It also appears that you previously signed it before I came out here. Is that correct?
Yes.
Mr. Reardon, did you witness that?
I did.
And you too, Mr. Flays?
Yes, Your Honor.
Very well, then the court will make that document part of the record at this point. And at this point, Mr. Coble, I'm going to review with you all the other rights you have that you're giving up by pleading guilty. And you first of all have a right to a trial. Now, a trial could be to me as a judge, where I would listen to all the evidence and I'd make that ultimate decision whether you're guilty or not guilty. But you also have a constitutional right to a jury trial, which will be in front of 12 citizens here from Lake County who would listen to all the evidence each side wanted to present. Those jurors would consider and weigh all that evidence, and then those 12 jurors would make that ultimate decision. And that ultimate decision reached by those 12 jurors would have to be unanimous. Unanimous means all 12 of them would have to agree together, one way or the other, whether you're guilty or not guilty. Do you understand that?
Yes.
Do you understand by pleading guilty you're giving up your right to have a trial?
Yes.
Now, if we did have a trial, you'd have the right to have an attorney represent you at the trial. If you could not afford an attorney, the court would appoint one for you free of charge. Do you understand that?
Yes, Your Honor.
Now, at any trial, the prosecutor here would be representing the state of Ohio, and he would have what we call the burden of proof. With the state having the burden of proof, what that actually means is that it's their job, or they bear the responsibility, the obligation, they bear the burden of proving you guilty at a trial before you could ever be found guilty. You're presumed innocent of this charge, and that presumption of innocence will stay with you and remain with you until the state, if at all, was ever able at a trial to overcome that presumption and prove you guilty. Do you understand that?
Yes.
Now, when I speak about this burden of proof, since it's a criminal charge we're dealing with, that burden is what we call proof beyond a reasonable doubt, highest burden we have in our justice system. And what it actually means, it's the amount of the evidence and the quality of all that evidence the state would have to present at a trial to prove you guilty. So in this case, the state would have to present evidence to prove each element or each part of the charge I just read to you beyond any reasonable doubt before you could ever be found guilty of that charge at a trial. Do you understand that?
Yes.
You understand by pleading guilty you're giving up your right to make the state of Ohio prove you guilty beyond a reasonable doubt at a trial?
Yes, Your Honor.
Now, in order to do that, or at least try to do that if we had a trial, the prosecutor would bring witnesses into the courtroom to testify for the state by answering questions from the prosecutor. Once those witnesses answer the prosecutor's questions, then your lawyer would have the right on your behalf to ask those same person's questions. That's called cross-examination. He could ask them anything he wanted to, but within certain rules. Do you understand that?
Yes.
Do you understand by pleading guilty you're giving up your right to cross-examine or confront those witnesses that would come in here and testify against you?
Yes.
Now, you'd also have the right at a trial. You can call your own witnesses to come to court to testify for you if you wanted to and answer your lawyer's questions. Now, you don't have to do that. You're not obligated to do that. But you have a right to do that if you want to. Do you understand that?
Yes.
And you further can request the court issue an order. That order we call a subpoena. What a subpoena would do is it would force or make someone come to court to testify for you and answer your lawyer's questions if they were not willing to come in voluntarily on their own. Do you understand that?
Yes, Your Honor.
Do you realize you're giving up that right?
Yes.
Now, you'd also have the right at a trial. You could choose to testify on your own behalf if you wanted to, but you do have a constitutional right not to testify if you don't want to. That's a decision or a choice that you would have to make. Do you understand that?
Yes.
And since that is solely your choice, what that really means then is that nobody else could force you or make you, nobody could compel you to testify against yourself at a trial if you didn't want to. I can't make you testify. But most importantly, the prosecutor here, he's not allowed to call you as a witness and make you get up on the stand and answer questions and testify. Your own lawyer can't make you testify if you didn't want to. Do you understand that?
Yes.
Further, if we were to go to trial and you were found guilty, you would have the right to appeal or challenge that guilty finding to another court that sits above me and reviews my decisions. Now, by pleading guilty here today, you're going to be giving up any right you would have to appeal a guilty finding that's not being made right now, but if down the road you violate the terms of the plan, you'd be found guilty of the charge at that point. By pleading guilty here today, you're giving up your right to appeal that guilty finding. Now, you'd be able to appeal any decision made by the court finding that you violated the plan, which caused us to do that. But the ultimate being found guilty, you're giving up your right to appeal that, as well as any other issues you could have raised or challenged or brought to my attention up to this point. Do you understand that?
Yes.
All right. Well, do you have any questions at all then about these rights we've just discussed? These are all the rights you have and all the rights you give up by pleading guilty. Any questions?
No questions at this time.
Do you understand them all?
Yes.
Do you still want to plead guilty?
Yes.
You understand a guilty plea is a complete admission of guilt. It means you're admitting to the facts being alleged by the state. We're not going to argue that you didn't do it or it's someone else's fault or anything like that. Do you understand that?
Yes.
Further, as a result of pleading guilty, the effect of that plea is that you'll be found guilty by the court, and then you will subsequently, well, strike that. I misstated. That's what we normally do. With the intervention in lieu of conviction, if I accept your plea, I'm going to grant your motion for intervention in lieu of conviction. I'm going to order a stay of all further criminal proceedings, which means you're not going to be found guilty and you're not going to be sentenced. I'm going to put you under a period of rehabilitation with the probation department with an intervention plan requiring you to follow certain conditions. If you were to violate any condition of that intervention plan or any of the rules of probation, we'd have a hearing here in court to see if you in fact did that. And if after that hearing I determined that you did, I would at that point vacate the stay of criminal proceedings, meaning I'd bring that coming back to court, I'd find you guilty of the charge that you're pleading guilty here today, and we proceed to sentencing. So again, I need to make sure you understand what those potential penalties could be if we ever get to that point, all right? Let me look at one thing real quick. I think I forgot to do something. I want to go back to the information real quick. I just omitted the forfeiture specification. I want to make sure we're all on the same page here. There's a forfeiture specification that's a part of this information which alleges that during the commission of the offense, you had in your possession a Glock 43 9mm handgun with ammunition and a Smith & Wesson 9mm handgun with ammunition that were used as instrumentalities. Instrumentalities is some type of property that's used to facilitate the commission of an offense. By finding that these are instrumentalities, that you would forfeit any ownership interest you have in this property. It doesn't enhance any potential penalty you could face later on, but you forfeit your ownership in that property. Do you understand that?
Yes, Your Honor.
And that would be something that will happen even if we're not proceeding to sentencing. As part of the intervention plan, you'll be forfeiting that. You understand that?
Yes, Your Honor.
All right. I omitted that, and I wanted to make sure you understood that before we get to the potential penalties here. So again, if we ever have to proceed to sentencing, you're pleading guilty to a felony of the 5th degree. This would be punishable by a possible term in prison of a minimum of 6 months, a maximum of 12 months, or any whole number in that range of 6 to 12. You understand that?
Yes, Your Honor.
Now, I believe I know the answer to this, but I'll ask you anyway. Are you currently on probation or parole, any supervision to any other courts or agencies?
No.
Any other charges pending against you anywhere right now?
No.
If a prison term was ever imposed in this case, upon your release from prison, you could be put on what's called post-release control. We sometimes call that parole or PRC. A period of supervision would be on after you completed the prison sentence. In this case, it could be up to 2 years. Do you understand that?
Yes, Your Honor.
And if you were ever on post-release control and violated any of the conditions of your supervision, the parole authority could send you back to prison as punishment for violating their rules for another 9 months for each separate violation you committed, up to ultimately a maximum of 50% or half of whatever the prison term was imposed by the court. Do you understand that?
Yes, Your Honor.
Now, aside from the possible prison sentence that it could impose if we ever proceed to sentencing, there's other sanctions that could be imposed, and some that will be a part of the intervention plan. You will be ordered to pay court costs and reimburse the county for any costs of confinement, community supervision, or treatment, if any that were applicable. Do you understand that?
Yes, Your Honor.
And you will also forfeit any ownership interest you have in the 2 firearms that are subjects of this charge. You understand that?
Yes, Your Honor.
Now, if we ever had to proceed to sentencing, I could also impose a fine of up to $2,500. Do you understand that?
Yes, Your Honor.
All right. Now, a few moments ago, I explained what the possible prison sentence could be. I used the word possible. Prison wouldn't be mandatory if you violated the intervention plan. You could still be put on probation, what's called community control sanctions. Do you understand that?
Yes, Your Honor.
Now, if that were to happen, you'd still have the conviction, but you'd be put on probation to the court. Just because you'd be eligible doesn't mean that's what would happen. It means I'll consider that if that's what you're going to be looking at, but I'll look at everything that's been going on, particularly what happened to bring us back here, and I'll make the decision at that point that I think is the right thing to do. Do you understand that?
Yes, Your Honor.
Now, if you're ever put on community control or probation, it could be up to 5 years. As the judge, I would have the discretion to order a wide variety of rules and conditions for you to follow, which could include an order that you serve time in the Lake County Jail of up to 6 months as a condition of your community control. Do you understand that?
Yes, Your Honor.
Further, if you were on community control and you were violated, we'd have a hearing to see if you're what's called a probation violator. If it was determined that you were, I could extend your probation up to 5 years if it wasn't originally 5 years. I could impose more restrictive sanctions against you, or I could terminate or end your probation and send you to prison at that point. And if I did it at that point, again, that could be 6 to 12 months in prison, which could also be consecutive to any other prison term you could be serving for something else or that you're being sentenced to at that time. You understand that?
Yes, Your Honor.
And the same goes with if you violated and I just sent you to prison initially. If you were serving another prison sentence for some new case or being sentenced at the same time, that could be consecutive. And consecutive means one after the other. You'd serve the prison term on one case first, finish it, then serve the prison term on the next case. You understand that?
Yes, Your Honor.
All right. All right, well, do you have any questions at all about the potential penalties you face by pleading guilty to the charge here today?
No, Your Honor.
You understand all the potential consequences?
Yes, Your Honor.
Do you still want to plead guilty?
Yes, Your Honor.
Have you had enough time in this case to discuss the matter with Mr. Reardon, have him review the report with you, discuss whatever issues there may be, and answer whatever questions you may have?
Yes, Your Honor.
Are you satisfied with his advice and counsel?
Yes, Your Honor.
Has he, I'll strike that, have you been threatened or coerced in any way to plead guilty?
No, Your Honor.
Are you entering this guilty plea freely and voluntarily?
Yes, Your Honor.
All right then, Mr. Coble, any questions for me at this point regarding anything we've talked about? The rights you're giving up, penalties you face, what you're pleading guilty to? No questions?
No questions at this time.
Do you need any more time to speak with Mr. Reardon before we go forward with your actual plea?
No, Your Honor.
All right, then what's going to happen at this point, the prosecutor here is going to briefly explain for me what he believes the facts would show if we had a trial. I want you to listen to him because I have some follow-up questions for you about that, all right?
Okay.
Mr. Flays?
Thank you, Your Honor. Had this matter proceeded to trial, the state would have proved beyond a reasonable doubt that on February 14th, 2026, in the city of Willoughby, Lake County, state of Ohio, the defendant did knowingly have 2 loaded handguns, a Glock 43 9mm handgun with ammunition, and a Smith & Wesson 9mm handgun with ammunition in a motor vehicle, and at the time of that possession was under the influence of alcohol. Thank you.
Thank you. Mr. Colville, were you able to hear what the prosecutor just had to say regarding what he believes the facts and evidence would show if we did have a trial?
Yes, Your Honor.
And what, if anything, do you have to say about those facts as he presented them? Are those facts true? Did you do what he said?
Yes, Your Honor.
Very well, then, regarding count 1, charging with improperly handling firearms in a motor vehicle, a felony of the 5th degree along with the forfeiture specification, what is your plea to that?
Guilty.
All right, I have in my possession at this time a 4-page document called a written plea of guilty and judgment entry, which sets forth and explains everything I've just explained to you. Before I can accept your plea, I need to make sure you understand what that document says and that you've signed that here in court. Now, again, my understanding is that before I came out here, you had a chance to go over that document with Mr. Reardon as well. Is that correct?
Yes, Your Honor.
Mr. Reardon, again, is that accurate? Did you read that over with Mr. Koval, answer all his questions?
I did, Your Honor.
Did he indicate an understanding of that to you?
He did.
Is that correct, Mr. Koval?
Yes.
It also appears that you signed the document. Did you sign it?
Yes, Your Honor.
Mr. Reardon, you witnessed that?
I did, Your Honor.
And Mr. Flays, you too?
Yes, Your Honor.
Very well, then. At this time, the court will accept the defendant's oral and written plea of guilty. Let the record reflect the defendant was here in open court with his lawyer advised of all his constitutional rights and made a knowing, intelligent, and voluntary waiver of all those rights. The court also finds the defendant understands the nature of the charge, the effect of the guilty plea, as well as the maximum penalty that can be imposed. Finding this to be knowing, intelligent, and voluntary, the court will accept the defendant's plea to count 1, improperly handling firearms in a motor vehicle, a felony of the 5th degree in violation of 2923.16D1. I will at this point grant the defendant's motion for intervention in lieu of conviction. I'm going to order a stay of all further criminal proceedings, including a finding of guilt and sentencing. Instead, I'm going to place the defendant under the supervision of the Lake County Adult Probation Department, and I'm going to order the implementation of the following intervention plan. 1 second. Again, you're going to be under their supervision for 2 years. I'm going to order that you successfully complete the treatment program that you're currently participating in at Wellbrook,
Yes.
and follow all of their aftercare recommendations. Is this the individual from Wellbrook?
Yes.
You guys put together some type of aftercare plan recommendations that, as part of the discharge plan? That's the word I was trying to come up with, yeah. Has that been done already for?
We're in the process of it, but we wanted to see what would happen today
Okay.
before we went further with it.
Fair enough. Well, conditions of your intervention plan, you are to, again, complete that program. I know it's about a week left before the inpatient portion is done. You will then have to comply with all of the aftercare recommendations, whatever those are. If that involves a recommendation for sober living, you're going to have to do that. Whatever those recommendations are, though, you're going to have to comply with that. I'm not going to order a separate, make a separate order for sober living, but if that's part of the recommendations, then it will be a separate order. Do you understand that?
Yes, Your Honor.
Further conditions, you're not to use any drugs or alcohol. That includes marijuana, too. You're to submit random urine screens or testing. Those have to be negative. Any positive screen for drugs or alcohol will result in a violation being filed and the intervention plan being found to be in violation and your treatment in lieu being terminated. You understand that?
Yes, Your Honor.
I want you to attend 3 AA meetings a week and have a sponsor. You're to obtain and maintain full-time employment. I want you to obtain a mental health evaluation if that wasn't done and follow whatever recommendations may be made for any type of counseling or treatment, as well as for any medications if that's deemed to be appropriate. I'm going to order the forfeiture of the firearms and ammunition. You're to pay your court costs and supervision fees. What's the status of your driver's license right now?
I believe it's under failure to reinstate. I had a payment plan that lapsed because I was incarcerated.
Okay. I'm not suspending your license or anything, but I'm going to order that as a condition of this intervention plan, you're not to drive a motor vehicle without a valid license or without valid driving privileges. So what that means is that if you drive a car, just because you don't get caught, or maybe you get caught but you don't get charged, or the charges get dismissed, you're still in violation. You understand that?
Yes, Your Honor.
So you don't have to be convicted of DUS to be in violation. If you're driving a car without valid license or valid privileges, then you're in violation of your community control, or not community control, the intervention plan, and it doesn't matter whether there's any other charges or anything. Got that?
Yes, Your Honor.
You're also not to own or possess any firearms during this period of time. You understand that?
Yes, Your Honor.
If you're caught with a firearm, this is going to get revoked, you're going to have a felony, and there's a good chance you're going to prison. Got that?
Yes, Your Honor.
All right. So being given a good opportunity here. I know you've been given opportunities before in the past. I think that's run its course. If this doesn't go away that we all hope it goes, there's not going to be any other breaks you're going to be getting. You understand that?
Yes, Your Honor.
Mr. Tompkins, do you want him to come stopping over now, or what do you want to do?
Yeah, I'll talk to him after
Okay.
you're done.
All right, I think that covers everything. Mr. Flay, is there anything else that we need to address that I've omitted?
Nothing further from the state of Ohio. Thank you, Your Honor.
I feel like I'm missing something. Mary, am I missing something? It's not. Huh? Well, yeah, I mean, it's not in community control, but if you do violate any of the conditions of this plan, again, a motion to terminate the intervention in lieu will be filed. If I find that you violated, I will vacate the stay of criminal proceedings. I will find you guilty of the charge you just pled guilty to, and will proceed to sentencing. And any of the sentences, potential sentences that I just reviewed with you, at that point could be ordered, including 12 months in prison. You understand that?
Yes, Your Honor.
All right. Mr. Reardon, anything else?
Nothing further, Your Honor.
All right, thank you all.
Thank you.
All rise.
Thank you, Your Honor. We're here in the state of Ohio versus Manon Futkos, case number 26CR355. The defendant is present with counsel Nicolette Tomasic. We were last here on April 27th, 2026, where the defendant pled guilty to count 1 of the information, attempted escape, a felony of the 4th degree, and we are here today for sentencing.
Tom, is there any reason not to go forward with sentencing?
No, Your Honor, we're prepared to proceed with sentencing.
Anything you want to say on behalf of your client?
Yes, thank you, Your Honor. We would like to ask the court today for an opportunity to place Ms. Futkos on community control sanctions. Your Honor, just to start, Ms. Futkos does not have a lengthy criminal history prior to this offense. She does have 2 misdemeanors and 1 prior felony out of Ashtabula County. Your Honor, regarding the incident offense, Ms. Futkos was in Nevaeh Ridge prior to getting sentenced to NeoCap. She was towards the end of her treatment. While at Nevaeh, Your Honor, she was prescribed Suboxone, Wellbutrin, and Buspar. She was working with a psychiatrist there. She was getting set up for sober living. She really enjoyed the treatment that she was getting there and the environment that she did get there. Your Honor, when she went to NeoCap, there was a period of a couple days where she was not getting her medication. She indicated to me she just essentially freaked out, panicked a little bit due to her mental health, and that's why she pulled the fire alarm and left. Your Honor, she is not taking this lightly. She understands the seriousness of the offense. I did speak with her regarding jail treatment program or continuing residential. She is interested in as much treatment as possible, Your Honor. She did have a very serious issue when it comes to drugs. Her and I've had many conversations about that. She also is interested in doing a program that does not have a MAP program. Since being in the jail, she's not getting her Suboxone. She's been feeling much better. She knows she can do it without all of that. So, Your Honor, we were going to get her on some wait lists for places. It was just a little bit difficult with our office to have residential set up for her with not knowing what Ashtabula was going to do in the holder, because we couldn't just pick her up from the jail and take her. But, Your Honor, if you would give her an opportunity of community control and consider the jail treatment program, I'm sure we could speak with Ashtabula, see if we can get that holder lifted to get her to residential. Thank you.
Ms. Futkos, you have the right to address this court before your sentence. You can say anything you want. Is there anything you want to say at this time?
Yes, Your Honor. I just want to say that at the time of the offense, I was not in my right state of mind coming off my mental health meds. I know I take full accountability of what I've done, but now that I've been sober and a clear mind, I know that I don't want this life for me. I know I'm better than that. I've had good jobs my whole life. I've been a good citizen my whole life. Just the drugs got a hold of me. And when I was at Nevaeh, I got a sponsor. I worked my steps. I got sober support, and that really helped me. I can finally be around my family again. My mom just had surgery. My sister just had her baby, so I'm finally allowed to be around them. So to be able to be around them would be great. And I just want to ask you for a chance. Thank you.
What do you mean you don't want to live that life anymore?
Drugs.
What's that life include?
Drugs. I mean, everything about drugs, wanting to get drugs, living my life for drugs. I got caught up around wrong people. And
Who?
Who?
Who are these wrong people that you get cut off with?
Just old friends, people, party people.
People that you're still keeping in touch with?
What? No, I've cut off everyone.
That's a lie.
I don't really talk to anyone. I talk to my family.
Mr. Randazzo, who's she been talking to in jail?
She's still trying to obtain contact with Malachi McDougal.
Oh, he's a good one, huh? Serving
Yeah.
time in prison right now for an F1.
Yeah, that's my ex.
Yeah, I know it's your ex.
Yeah.
Think he's a good influence?
No.
Yeah, but you're still trying to get a hold of him. Find out ways to get a hold of him.
I
Who else, Mr. Randazzo?
She's had contact with felony probationers and Lamar Wright.
Those are good ones, huh?
I didn't know they were on felony probation.
She's had contact with an Alexandria Thomas who has a felony warrant.
I didn't know that either.
These are all people that you're supposedly trying to make yourself a better life for and get away from drugs. All these people that are doing this all themselves.
I think that it's because I'm alone in jail right now. But when I'm on the outside, I'm going to be staying with my family.
You're in jail and you're reaching out to people who are into the same culture as that you were in, and supposedly that you don't want that life anymore. That's who you're talking to.
I don't know them all like that,
Oh,
but I do take full accountability.
yeah. Ms. Thomasek, anything else for the defense?
Nothing additional, Your Honor. Thank you.
For the state?
Thank you, Your Honor. The state is asking for community control sanctions.
This court has reviewed the pre-sentence report and investigation. Consider the facts and circumstances of the underlying offense, the nature of that offense. I've considered what's been said here in court today by the defendant, her lawyer, the prosecutor, the recommendations. All this is considered in light of the purposes and principles of felony sentencing set forth in 292911 of the revised code. As for the factors in 292912, factors indicating the conduct is more or less serious. The court finds that just the specific facts and nature of this case make it more serious than normal. Our normal escape is somebody that is let out on a furlough, let to go somewhere, and they don't come back when they're supposed to come back. That's the normal escape we deal with. This escape is a true escape. You're in a locked facility, and you do something to break out and get out. And what you did was actually set off an alarm, a fire alarm, which is inducing panic to other folks, causing emergency personnel to have to react and respond. And that's what you did to escape here. So the conduct involved here is much more serious than the normal escape that we deal with here when we have escape charges. There's nothing that makes it less serious. As for recidivism factors, you were on community control sanctions at the time you committed this offense. You have prior criminal convictions. You've not responded favorably to the previously imposed sanctions. The one sanction that you got, you were there, you didn't like it. You didn't like what you were ordered to do, so you did what you needed to do to get out of it. You wanted things done your way, and it wasn't done your way, so you took matters into your own hand to get out of what was the sentence you were sentenced to. You want to go back to Nevaeh Ridge, which you wanted to do all along. What kind of precedent would that set? Anybody that gets sentenced to NeoCap that doesn't want to go to NeoCap just has to pull a smoke alarm, escape, then they get to go to where they want to go to. That's what we're going to do. That's going to be everybody that goes there. They're not going to want to go, and they're going to learn, wow, this one gal that went there, she pulled the fire alarm, she escaped, and then she was able to be continued on probation and go to where she wanted to go all along. Does that make any sense?
No.
That you wanted to go to Nevaeh Ridge all along, you didn't get what you wanted, so you're there for 2 days, you do these shenanigans, you escape, and then you get to end up where you wanted to go all along? Does that make any sense?
I understand.
No, I'm not about to set that precedent. Problem is here, NeoCap won't take you back, and I don't blame them. I want to take someone back either that engaged in this conduct and caused this chaos. But I'm not sending you to the residential facility that you wanted to go to all along. That would make no sense to the court. It would allow you just to get exactly what you wanted from the very beginning, and that's not going to happen. Prison's consistent with the purposes and principles of sentencing here with this conduct, and you're not amenable to any available community control sanctions this court has at its disposal. Therefore, as a sentence of this court, then on count 1, you see a term in prison of 8 months. You have credit for 87 days you've served. I need to advise you upon your release, you may be put on post-release control for up to 2 years. If you violate any of those conditions, the parole authority can return you to prison as punishment for violating their rules for another 4 months, the maximum being 50% of the term I just imposed. Any additional prison term imposed for violating post-release control is being imposed as a part of the sentence at this time. Court disapproves of your placement in a program of shock incarceration, intensive prison program, or transfer to transitional control, and you're ordered to pay all costs incurred in this action. Is there anything else for the record, Ms. Gold?
No, Your Honor, thank you.
Ms. Tomazik?
Nothing further, Your Honor.
State of Ohio versus Christopher Charlton, cases 26 CR 188 and 26 CR 654. The defendant is present with counsel Nicolette Tomasic. And case 26 CR 188, we were last here on April 13th, 2026, where the defendant pled guilty to count 1 of the information, possession of heroin, a felony of the 4th degree in violation of Ohio Revised Code Section 292511A. And we are here for sentencing on that case. In case 26 CR 654, a 1-count information was filed on May 28th, 2026. The 1 count is possession of cocaine, a felony of the 5th degree with a forfeiture specification. It is the state's understanding that today the defendant would like to waive his right to have the Lake County Grand Jury indict this case and will be pleading guilty by way of information, and after which we will proceed to sentencing on both cases.
Thank you. Any agreement between the parties regarding any recommendations for sentencing?
No, Your Honor. The state has informed defense counsel we will be recommending prison.
Tomasic, does that all sound accurate?
Yes, it does, Your Honor.
Mr. Charlton, were you able to hear what the prosecutor and your lawyer just had to say regarding what they believe your intentions are here at this time?
Yes, Your Honor.
They indicated to the court they believe it's your desire to waive your right, this is on the new case that we're here for, waive your right to have this case presented to a grand jury and to then go forward and plead guilty by way of what's called an information to this new charge, following the 5th degree drug possession charge. We would then incorporate the pre-sentence report that was done on the other case into this case and proceed to sentencing on both cases where there's no agreement between the parties regarding any recommendations. Each side is free to recommend to the court whatever sentence they believe is the right thing to do. Is that your understanding of the discussions that took place between your lawyer and the prosecutor, most importantly, what you want to do today?
Yes, Your Honor.
Well, before I can accept your plea, I need to make sure you understand everything going on here. I need to make sure you understand what it is you're charged with and pleading guilty to, the rights you have that you give up by pleading guilty, as well as all the possible penalties you face. So for me to determine those issues, I'm going to ask you a series of questions. If at any point when I'm asking you the questions, if you're unsure, unclear of anything I'm asking you, if you need anything repeated or clarified, if you want a moment to speak with your lawyer to ask her questions, or even if you want to ask me questions, make sure you let me know that, because I need to make sure you understand everything going on, all right?
Yes.
All right, well, let's get started then. How old are you, sir?
34.
Are you able to read and write the English language?
Yes.
Any difficulty with that or difficulty understanding what you read in the English language?
None.
Are you a U.S. citizen?
Yes.
Now, prior to coming into court here today, have you any drugs or alcohol of any kind?
None.
What about within the last 48 hours?
No.
Not even prescribed medication, nothing?
Nothing.
Now, did you receive a copy of the information that was filed in this new case?
Yes. Yes.
Had a chance to look that over?
Yes.
In that information, you are charged with 1 count. What's alleged here and what you'll be pleading guilty to and admitting to is on or about April 28th, 2026 in Painesville Lake County, Ohio, that you did knowingly obtain, possess, or use cocaine, excuse me, or some compound mixture, preparation, or substance which contains cocaine. The amount involved did not equal or exceed 5 grams, which makes the offense possession of cocaine a felony of the 5th degree. Do you understand what you're charged with and pleading guilty to in regards to count 1 here?
Yes, Your Honor.
Any questions about it?
No, sir.
Now, the charge also carries with it what's called a forfeiture specification that alleges during the commission of the offense you possess or had an interest in property considered to be contraband or an instrumentality. Contraband is property that's illegal just by the nature of the property, like drugs. An instrumentality is some type of property that there may not be anything illegal about it, but it's being used in an illegal manner to facilitate a crime, and you can't use or possess it for that purpose. Here it's alleged that drugs as well as a pipe were possessed by you as contraband and instrumentalities. The whole point of this is that you forfeit any ownership interest you have in the property. It doesn't increase any potential penalty you face, but it allows the state to be able to dispose of it properly at the end of the case. You understand that?
Yes.
Any questions about it?
No, sir.
Well, then before I can accept your plea, I need to make sure you understand all the rights you are giving up by pleading guilty. And you, first of all, have the right to have this case presented to a grand jury. So that document I just read to you is called an information, and that's a criminal charge brought by the prosecutor's office without the case having previously been reviewed or considered by a grand jury. And what a grand jury is, it's made up of a group of citizens here from Lake County that get together and they meet privately. They meet in secret for the purpose of evaluating evidence in cases to determine whether probable cause exists that a person committed a crime. Probable cause is defined as some evidence that would suggest a person probably committed a criminal offense. Everyone here in Ohio accused of a felony has the right to have a grand jury independently review the evidence in a case and make a decision without the government being involved in that decision, whether someone should be charged or not. You have that right as well. But you can give up that right if you desire and go forward in the charge brought by the prosecutor in this information. And she has indicated she believes that's what you want to do. Is that correct?
Yes.
Well, before I can go any further, I need to have you acknowledge that here in open court in writing. And I have with me here a one-page document called a waiver of indictment, which sets forth what I just explained to you about the grand jury process and that you want to give up that right.
Yes, sir.
Before I can go further, I need to make sure you understand that document, that you sign it here in open court. Now, my understanding is before I walked out here, you had a chance to go over that with your lawyer. Is that correct?
Yes.
Ms. Tomazik, is that accurate? Did you review that with Mr. Charlton, read it over, answer his questions?
Yes, Your Honor.
Did he indicate an understanding of it to you when you did that?
Yes, he did, Your Honor.
Is that correct, Mr. Charlton?
Yes.
So you understand what it says?
Yes.
Any questions for me about it?
No, Your Honor.
It also appears you signed the document. Did you sign it?
Yes.
You witnessed that, Ms. Tomazik?
Yes, Your Honor.
You also, Ms. Gold?
Yes, Your Honor.
Very well, that document will be made part of the record. At this point, I'm going to review with you all the other rights you have that you're giving up by pleading guilty, and you first of all have a right to a trial. And a trial can be to me as a judge where I listen to all the evidence and I make that ultimate decision whether you're guilty or not guilty. But you also have a constitutional right to have a jury trial. A jury trial would be in front of 12 citizens here from Lake County who would listen to all the evidence each side wanted to present. The jurors would consider and weigh all that evidence, and those jurors would make that ultimate decision. And that ultimate decision reached by those jurors would have to be unanimous. Unanimous means that all 12 of them would have to agree together one way or the other as to the charge, whether you're guilty or not guilty. Do you understand that?
Yes.
Do you understand by pleading guilty you're giving up your right to have a trial in this case?
Yes.
Now, if we had a trial, the prosecutor here would be representing the state of Ohio, and she would have what we refer to as the burden of proof. With her having the burden of proof, what that actually means is that it is her job, excuse me, I'm sorry, or that she bears the responsibility or the obligation of proving you guilty before you can be found guilty. You're presumed innocent of the charge. That presumption of innocence stays with you and remains with you until the state, if at all, is ever able at a trial to overcome that presumption and prove you guilty. Do you understand that?
Yes.
Now, when we speak of that burden of proof, since this is a criminal case, that burden is what we refer to as proof beyond a reasonable doubt, highest burden we have in our justice system. And what it actually means is the amount of the evidence and the quality of that evidence the state would have to present at a trial to prove you guilty. So in this case, the state would have to present evidence to prove each element or each part of the charge beyond any reasonable doubt at a trial before you could ever be found guilty. You understand that?
Yes.
You understand by pleading guilty you're giving up your right to make the prosecutor prove you guilty beyond a reasonable doubt?
Yes.
Now, in order to do that, or at least in order to try to do that if we had a trial, the prosecutor would call witnesses to come to court to testify for the state and answer questions from the prosecutor. Once those witnesses answered the prosecutor's questions, then your lawyer would have the right on your behalf to ask those same person's questions. We call that cross-examination. She could ask them anything she wanted to within certain rules. Do you understand that?
Yes.
Do you understand by pleading guilty you're giving up your right to cross-examine or confront those witnesses that would come in here and testify against you?
Yes.
Now, you'd also have the right at a trial. You could call your own witnesses to come to court to testify for you if you wanted to and answer your lawyer's questions. Now, you don't have to do that. You're not required to do that, but you have a right to do that if you want to. Do you understand that?
Yes.
And you further can request the court issue an order. That order we call a subpoena. What a subpoena would actually do is force or make someone come to court and testify for you and answer your lawyer's questions if they weren't willing to come in voluntarily on their own. Do you understand that?
Yes.
Do you realize you're giving up that right?
Yes.
Now, you also have a right in a trial. You could choose to testify on your own behalf if you wanted to, but you do have a constitutional right not to testify if you don't want to. That's a decision or a choice that you would have to make. Do you understand that?
Yes.
And since that's your choice, then what that really means is that nobody else could force you or make you. Nobody could compel you to testify against yourself at a trial if you didn't want to. I can't make you testify. But more importantly, the prosecutor is now to call you as a witness and make you get up on the stand and answer questions and testify. Your own lawyer can't make you testify if you didn't want to. Do you understand that?
Yes.
To further understand, if we went to trial and you were found guilty of this charge, you would have the right to appeal or challenge that guilty finding to another court, a court that's higher than me and reviews my decisions. By pleading guilty here today, you're giving up or waiving any right you have to appeal a guilty finding. The court will enter if I accept your plea, as well as any other issues you could have raised or brought to my attention up to this time. Do you understand that?
Yes.
Do you have any questions then regarding any of these rights that we just discussed? These are all the rights you have and all the rights you're giving up by pleading guilty. Any questions?
No, Your Honor.
You understand them all?
Yes.
You still want to plead guilty?
Yes.
You understand a guilty plea is a complete admission of guilt. It means you're admitting to the facts being alleged by the prosecutor. We're not going to argue later that you didn't do it or it's someone else's fault or anything like that. Do you understand that?
Yes, sir.
Further, as a result of pleading guilty, the effect of that plea is that you will be found guilty by the court, and then you will subsequently be sentenced by the court. Do you understand that?
Yes, Your Honor.
Now, as far as sentencing goes, you're pleading guilty to a felony of the 5th degree in this case. That offense is punishable by a possible term in prison of a minimum of 6 months, a maximum of 12 months, or any whole number in that range of 6 to 12. Do you understand that?
Yes.
Are you currently on probation or parole to another courts or agencies?
No, sir.
You know, obviously you have the other case pending before me that we're here for. Any other charges pending against you anywhere?
No, sir.
At the time of sentencing, in this case, you're also going to be getting sentenced on the other case that I have. As the judge, if I impose a prison sentence in both of those cases, I do have the discretion to run those sentences either concurrent or consecutive. Concurrent means together. You serve them at the same time, whereas consecutive means one after the other. You'd serve the prison term in one of the cases first, complete that, then serve the prison term in the other case. You understand the difference there?
Yes.
So the prison sentence in this case, if it's imposed, could be consecutive to the prison term in the other case. You understand that?
Yes, sir.
All right. If a prison sentence is imposed in this case, upon your release from prison, you could be put on what is called post-release control, sometimes called parole or PRC. It's a period of supervision you would be on once you completed the prison sentence, and it could be for up to 2 years. Do you understand that?
Yes, sir.
And if they do put you on post-release control and you violate any of the conditions of your supervision, the parole authority could send you back to prison as punishment for violating the rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half of whatever the prison term was imposed by the court. Do you understand that?
Yes, sir.
Now, aside from the possible prison sentence, there's some other sanctions that could be ordered. You could be fined up to $2,500. You could be ordered to pay court costs. You could also be ordered to reimburse the county for any costs of confinement, community supervision, or treatment, if any that were applicable. Do you understand that?
Yes, sir.
I could also suspend your driver's license up to 5 years. Do you understand that?
Yes.
And as I alluded to earlier, any right, title, or interest you have in the property set forth in that specification, I think it was cocaine in a pipe, that would be forfeited to the state of Ohio. Do you understand that?
Yes.
Excuse me. Now, a few moments ago, I explained the possible prison sentence. I used the word possible. Prison is not mandatory. With this charge, you are eligible for probation, or what is referred to as community control sanctions. Do you understand that?
Yes.
You understand just because you're eligible doesn't mean you automatically get put on probation. It means I consider that, if that's what you're requesting. I'll look at all the information presented, then I'll make the decision that I believe is the right thing to do. Do you understand that?
Yes.
Now, if you are put on probation, it could be up to 5 years of supervision, and as a judge, I have the discretion to order a wide variety of rules or conditions for you to follow. One of the conditions could be an order that you serve a term in the Lake County Jail of up to 6 months as a condition of probation. You understand that?
Yes.
Further, if you are on probation and you ever violate any of the conditions of your supervision, we would have a hearing here in court to see if you're what's called a probation violator. If it was determined that you were, I could extend your probation up to 5 years if it wasn't originally 5 years. I can impose more restrictive sanctions against you, which could include local jail time, or I could terminate your probation and send you to prison. If I sent you to prison at that point, again, that could be 6 to 12 months, be consecutive to any other sentence you may be serving at that time or that you're being sentenced to at that time. You understand that?
Yes.
Lastly, when we do proceed to the sentence at that time, say anything you want. Anything you want me to know or consider. Your lawyer could speak on your behalf. She can recommend the sentence to the court. The prosecutor can also recommend the sentence to the court. Do you understand that?
Yes.
Do you understand that whatever the lawyers say at sentencing regarding what they think the sentence should be, it is just what I said. It's a recommendation. I don't have to follow that if I don't think that's the right thing to do. Do you understand that?
Yes.
All right, well, do you have any questions at all about the potential penalties you face by pleading guilty?
No, Your Honor.
You understand all the possible consequences?
Yes, sir.
Do you still want to plead guilty?
Yes, sir.
Have you had enough time to discuss this case with your lawyer and have her review all the reports with you and discuss the issues?
Yes, sir.
Are you satisfied with the advice and counsel of your lawyer?
Yes.
Has she or anyone else made any promises to you about what's going to happen at sentencing, which is inducing you to plead guilty here?
No, sir.
Have you been threatened or coerced in any way to plead guilty?
No, sir.
Are you entering the guilty plea freely and voluntarily?
Yes.
All right, then. Do you have any questions for me at this point regarding anything we've talked about? The rights you're giving up, the penalties you face, what you're pleading guilty to? Any questions at all?
No, sir.
Do you need any more time to talk to your lawyer before we go forward with your actual plea?
No, sir.
All right, then what's going to happen at this point, the prosecutor here is going to explain for me what she believes the evidence would show if we had a trial. I want you to listen to what she says because I'll have some follow-up questions for you, all right?
Yes.
Ms. Gold?
Thank you, Your Honor. The facts would show that on April 28, 2026, officers in Paynesville, Lake County, Ohio, conducted a traffic stop on a vehicle that the defendant was a passenger in. The stop resulted in a search of the car where officers located suspected controlled substances determined to be in the defendant's possession. The suspected controlled substances were taken to the Lake County Crime Lab and tested positive for less than 5 grams of cocaine, a Schedule II controlled substance.
Thank you. Mr. Charlton, were you able to hear what the prosecutor just had to say regarding what she believes the evidence would show if we had a trial?
Yes, Your Honor.
And what, if anything, did it say about those facts as she presented them? Are they true? Did you do what she said?
Yes, sir.
Very well, then, regarding count 1, charging with possession of cocaine, a felony of the 5th degree with the forfeiture specification, what is your plea to that count at this time?
Guilty.
All right, I have in front of me right now a 4-page document called a written plea of guilty and judgment entry, which explains everything I've just explained to you. Before I can accept your plea, I need to make sure you understand what this document says and that you sign it here in open court. Now, my understanding is that before I walked out here, you had a chance to go over this document with your lawyer. Is that correct?
Yes, sir.
Ms. Tomaszek, is that accurate? Did you review this with Mr. Charlton and read it to him, answer all his questions?
Yes, Your Honor.
And did he indicate an understanding of the document to you when you did that?
Yes, he did, Your Honor.
Is that correct, Mr. Charlton?
Yes.
Do you understand what this document says?
Yes.
Any questions for me about it?
No, sir.
Now, it also appears you signed the document. Did you sign it?
Yes.
You witnessed that, Ms. Tomaszek?
Yes, Your Honor.
You too, Ms. Gold?
Yes, Your Honor.
Very well, then. At this time, the court will accept the defendant's oral and written plea of guilty. Let the record reflect the defendant was here in open court with his lawyer advised of all his constitutional rights, made a knowing, intelligent, and voluntary waiver of those rights. The court also finds the defendant understands the nature of the charge, the effect of the guilty plea, as well as the maximum penalty that can be imposed. Finding this to be knowing, intelligent, and voluntary, the court will accept the defendant's plea. Find the defendant guilty of count 1, possession of cocaine, a felony in the 5th degree in violation of 292511 of the revised code with the forfeiture specification. I'm going to incorporate the pre-sentence report that was done in the other case into this case, so it'll be taken into consideration in both cases. And with that done, Ms. Tomaszek, is there any reason not to go forward with sentencing?
No, Your Honor, we're prepared to proceed with sentencing.
Is there anything you want to say on behalf of your client?
Yes, thank you, Your Honor. We'd like to ask the court today for an opportunity to place Mr. Charlton on community control sanctions. Your Honor, I am aware that Mr. Charlton does have a criminal history. Your Honor has sent him to prison prior for not appearing for his pre-sentence report. Most, if not all, of his criminal history is related to drugs, Your Honor, so I do know Mr. Charlton does want to get that under control. Mr. Charlton indicated he's fairly open to any treatment that the court would see fit. Your Honor, prior to the original plea on April 13th, Mr. Charlton did go to Signature Health to do a drug and alcohol assessment. He was set to start IOP there. He was also set to get set up with a primary care physician along with a dentist because he has been not prioritizing that, Your Honor. He also has been taking steps to get his license back. He owes a decent amount of money to the Attorney General's office due to court costs in prior cases. He has paid on that on a few different occasions. I do have receipts of that if Your Honor would like to see them. So we'd just like to ask the court today for an opportunity to allow Mr. Charlton to do treatment. Thank you.
Thank you. Mr. Charlton, you have the right to address the court before your sentence. You can say anything you want. Is there anything you want to say? This is for both cases that we're dealing with at this point.
Yes,
the one we just pled to plus the other one.
I'm just embarrassed and I'm ashamed of myself to be even in this position again. You know, usually I'm against the grain. Before sentencing, for once in my life, I wanted to be proactive, you know, and try to get into some IOP. I'm tired.
Trying what?
Try to get into an IOP.
That's all you think you need is IOP?
Well, I mean, probably more than that, truthfully.
Well, you're out on bond in this case after pleading guilty to felony charges and you committed another felony charge. You've been to prison for drug cases before.
Yeah, I mean, I'm not perfect.
I'm not trying to imply that any of us are perfect. I'm trying to imply that you were out and about on your own on bond and you couldn't stop using. Why do you think you could be able to be out and about on an outpatient basis and be able to not use and get help and do well?
Well, I've had an 18-year opiate addiction, and usually I'm against the grain. I get out and I start using immediately. I was sober for over a month. I went to my PSI, passed my piss test, got health insurance, went to Signature, did their IOP or did their assessment, got an IOP, paid over $800. Within the month I was out, paid over $800 to try to get my license back, trying to do the right thing. I just slipped up. I had some stuff going on mentally, and I'm like I said, I'm embarrassed of what happened and being here today under these circumstances, sir. But I'm a man that's trying, you know, and which is more than I could say for any other past of my life, you know.
When you went to the probation department during your interview, you told them you don't want to be on felony papers and you've done treatment before.
That's not very accurate. I am afraid because of my license that I'm not going to be able to make it everywhere. I don't have much help. The whole reason this kind of happened is I bought the girl I was talking to a car, and she kind of started talking to her ex, and you know I felt hurt and I wanted to numb my feelings, truthfully.
Is that Regina?
Yes.
She wasn't a real good influence either, was she?
No, she wasn't at all. And I mean, I see where I went wrong, and I learned a lesson from it. If anything, you know, everything has to happen for a reason. That's what I try to tell myself. But I see where I went wrong, and I know I can.
You're still trying to keep in touch with her and remain.
I talk to her because I feel bad because she don't have anybody, but that's literally all it is. I know I need to prioritize myself instead of trying to put other people first and trying to help others when I can't even help myself. I just figured, you know, if I helped her get a car and get a license, that I'd be able to make it to my IOPs. I'd be able to go to my probation appointments instead of me getting another driving under suspension.
No, you're still trying to keep in touch with her.
No, this was before.
I understand what you're talking about before. I'm talking about now. You're still trying to keep in touch with her.
I talked to her. I was talking to her, yes. I mean, I've spent every day with her for 2 years, you know.
Well, you just blamed her for the relapse.
I see it now. I see it wasn't the best thing to do. But
I mean, the way you said it was like, this girl screwed me over, and
it wasn't like that forever.
You know, I started using because of it, and then was a bad influence on me. But you're still wanting to be with her.
We were both sober at this point until I got her a car, and then she started using and seeing her ex, and I felt abandoned, hurt, and used and abused, truthfully. And then I started my downhill spiral. So I see where I went wrong, but we had good intentions at first.
I understand that. My point is, right now, still today, you're still communicating with this woman who is going to prison for drugs, and you're still wanting to have a relationship with her.
I have a heart, sir, and it's hard to let people go, I guess. Especially when you got someone tugging on your heartstrings.
Is there anything else you'd like to say?
No, sir, I'm sorry. I'm in this position.
I'm sorry, excuse me.
You know, I'm just embarrassed and ashamed of myself, truthfully.
Ms. Tomaszek, anything else?
Nothing further, Your Honor. Thank you.
Ms. Gold for the State of Ohio.
Thank you, Your Honor. The state is asking for a prison sentence in this case. The defendant was out on bond in case 26 CR 188 when he committed the offense in case 26 CR 654, a violation of his bond. The defendant has previously served a prison sentence after being sentenced by this court in a prior possession case when the defendant failed to report to probation for his pre-sentence report interview. The defendant has been on community control sanctions in the past and has had community control violations in those cases, and the state does not believe the defendant is amenable to community control.
This court has reviewed the pre-sentence report and investigation, the drug and alcohol evaluation. I've considered the facts and circumstances of the offenses involved in each of these cases. These findings I'm making are for both cases unless I specifically say otherwise. I've considered everything that's been said here today by the defendant, his lawyer, the prosecutor. All this is considered in light of the purposes and principles of felony sentencing set forth in 29-2911. For the factors in 29-2912, factors indicating the conduct is more or less serious. Nothing stands out factually indicating it's more or less serious. As for recidivism factors, many of these factors are present. The defendant has a history of criminal convictions, as well as juvenile delinquency adjudications. He has previously served a prison term before. He has been on probation before in the past and has failed to comply with the previously imposed sanctions ordered by courts, which is a factor indicating recidivism is more likely. There is a drug abuse problem that relates to the offense, and I don't know how much the defendant, he knows he has a problem, how much he truly wants to get the help that is needed to, necessary to address this. This has been a lifelong problem almost. And he couldn't remain sober and not get a new felony charge when he was out on bond. In case 26 CR 654, he was on bond to the court in 188 when he committed the offense. Prison is certainly consistent with the purposes and principles of sentencing. Now, the defendant also violated the conditions of his bond in 188 by picking up a new offense. Prison is consistent in both cases with the purposes and principles of sentencing. The question is whether you're amenable to community control sanctions, and I don't know the answer to that. I do know you previously served a prison term. That prison term was imposed because you didn't show up for your pre-sentence report. It wasn't imposed because you were put on probation and violated. Had you shown up, most likely you would have gotten probation. It's very rare that somebody with just a possession charge goes to prison unless they've been on probation before and just always failed. And you have been on probation before, but never to this court. If I give you a chance, Mr. Charlton, it's not going to be IOP. I mean, you're going to get, it's going to be NeoCap. I'm going to order to give you what we have, which is the best that we have, because that's the only chance of success you're going to have, is to spend the time, put the effort in to learning better ways to think and make decisions and address these issues as well. If that's something that you're willing to give an effort at, I'll give you that one chance. It's going to be one chance, but it's not going to be any other options, and you're only going to get that one opportunity. That's something you want to do?
Yes, sir.
I'll give you a chance. I'll find you're amenable to that. I'm going to put you on 2 years of community control sanctions. This is for both cases. What's the credit breakdown? I know on the older case, the PSR shows 41 days. What about was it just 1 day less? No, he had some credit from the initial arrest, probably too.
Yes, Your Honor, on the initial arrest, the defendant has...
I'm talking about the old case.
7 days.
So then in the old case...
8 days, initially, prior to his arrest, for the bond revocation.
Let me get this right. On the new case, he committed it on the 28th. So he's been on the new case since April 28th, right?
Yes, Your Honor.
So we figured that out before, didn't we? That's 28, 29, 30, so it's 34, 35 days counting today on the new case. Is that right? 28, he's arrested on the 28th? That's when the new one was?
Correct, Your Honor.
30. Yeah, 35 days in the new case. And the old case is 41 days? Is that what you had in school?
Yes, Your Honor.
That's what PSR shows now. All right, in each case, I'm going to order that you serve 90 days in jail. On 188, you have 41 days of credit. On 654, you have 35 days of credit. I am going to order that you immediately enter and successfully complete the jail treatment program. Upon successful completion of that program, you shall be released from the jail once a bed is available. Is that going to be enough time? That's like 50 days. So,
Yes, sir, he doesn't have any warrants.
okay. So once JTP is successfully completed, you are to be released from the jail upon a bed becoming available at NeoCap. To enter NeoCap and successfully complete the program. Any balance of the jail time that's left will be vacated or suspended. Successfully complete NeoCap. Upon completion of NeoCap, I'm going to order at this time, you're probably not going to have to do this, but you're going to return to the jail for 30 days and participate in the transitional day reporting program. Now again, you probably aren't going to have to do this, but what this is a program that helps people make the transition from being locked up to being on their own. Many people, when they've been out of society for a while. When they're set free, they have nowhere to go. They have no housing set up. They have no work set up. And this program helps them make that transition. But when NeoCap's over, if you've got housing lined up, if you've got work lined up, and that's stuff you can work on while you're at NeoCap, if that's all ready to go, I'll vacate those 30 extra days. You won't have to do them. But it's a good program for those that need that help, so I put it in place for everybody that goes to NeoCap. And again, I get vacated if it's not necessary. The probation department will let me know that at the end. Further conditions, again, for both cases, you're not to use any drugs or alcohol. Shall submit random urine screens when requested. They have to be negative. A positive screen is a violation. To attend 3 AA meetings a week and have a sponsor. Obtain and maintain full-time employment. Take all medications as prescribed, pay court costs and supervision fees. And order the forfeiture of whatever contraband and instrumentalities are part of the specifications. You'd have no contact with Regina Patterson. That means in any capacity. It means not just face-to-face, it means phone calls, it means emails, text messages, it means causing other people to have contact with her. You're not to do that. Jennifer, is there anything else I should be thinking about or considering here?
Your Honor, unless you wanted to order an affidavit valid driver's license.
Yeah, I'm going to order you to make a reasonable effort to obtain your license. It's going to make your life a lot easier. And it sounds like you're trying to do that now, but you need to make a reasonable effort at obtaining that. And I'm also going to order that I'm not suspending your license, but I'm ordering that you not drive a vehicle without a valid license or without valid privileges. So what that basically means is if you drive a car, it doesn't matter if you get charged, convicted of DUS or any offenses. If you get arrested for it and the charges get dismissed, or they can prove you were driving still, you're in violation. If someone sees you driving, you're in violation. I'm not suspending it, but you can't drive without a valid license or valid privileges. You understand?
Yes.
So, Mr. Charlton, you understand all the conditions of your community control sanctions in each of these cases?
Yes, sir.
Any questions for me?
No, sir.
I need to advise you, if you fail to comply with any of these conditions, any of the rules of probation, if you leave Ohio without permission from the court, or if you commit another offense while you're on probation, a motion to terminate your community control sanctions will be filed. If it's found that you violated, that could extend your probation up to 5 years if it wasn't originally 5 years. Well, it wasn't originally 5 years. I can extend your probation up to 5 years. I can impose more restrictive sanctions against you, including jail time, or I could terminate your probation and send you to prison. That's what's going to happen. And in case 26 CR 188, it'll be 18 months in prison. In case 26 CR 654, it'll be 12 months in prison. Those two terms will be consecutive to each other. So 2.5 years in prison is what's hanging over your head. You understand that?
Yes.
All right. And that could be consecutive also to any other case prison term you may be serving for some other case, or for some new sentence that something were to happen and you get arrested, and a new case, it could be consecutive to that also. You understand that?
Yes.
All right. I will release bond in the old case. He wasn't that he failed to appear, so bond's not getting forfeited in that case. So bond will be released in 188. All right. Ms. Gold, anything else?
No, Your Honor, thank you.
Ms. Tomaszek?
Nothing further, Your Honor. Thank you.
Ms. Wood?
Thank you, Your Honor. We're present in case State of Ohio versus Alfonso Z. Goddard, case number 26-CR203. The defendant is present today in court represented by attorney Jim Matthews. We were previously in court April 22nd of this year. The defendant pled guilty to count 1, identity fraud, a felony of the 5th degree with the forfeiture specification. This matter was then referred for a pre-sentence report and victim impact statement, and we are set for sentencing here today. Thank you.
Mr. Matthews, any reason not to go forward with sentencing?
No, Your Honor.
Anything you want to say on behalf of your client?
Yes, thank you. Your Honor, we previously did present to the court a joint recommendation for 8 months in prison. I do not believe that Mr. Goddard is currently requesting that sentence. I am a bit uncertain actually as to what precisely he wants to ask the court for. Obviously, he, in the pre-sentence report, did request that the court consider a sentence of 6 months local jail followed by probation. Thank you.
Mr. Goddard, you have the right to address this court before your sentence. You can say anything you want. Is there anything you want to say at this time? Is that a yes or no?
No.
Mr. Matthews, anything else?
No, Your Honor.
Ms. Wood, from the state of Ohio.
Thank you, Your Honor. On behalf of the state of Ohio, the state's understanding is that we did have a joint recommendation for 8 months, but it appears that that is no longer the same recommendation to the court from the defendant, so the state is recommending more than 8 months in prison. This was an offense where the defendant was a passenger in a motor vehicle that was reported stolen. Inside the vehicle and on the defendant's person, he had fraudulent paper driver's license. He was arrested and admitted at the Willoughby Police Department to utilizing those those fraudulent IDs that all had his photograph on them to make fraudulent returns at different stores. In this case in particular, it was at the Target where the car was located in the parking lot. At the time of this offense, the defendant was on post-release control supervision. He had been sentenced to prison before. He had violated his post-release control supervision, was returned on a sanction, and then was released and out. He never reported to his parole officer after his second release from prison. He has a criminal history as an adult, as well as juvenile adjudications and a commitment to Indian River Juvenile Detention Facility. So the state does not believe that the defendant would be an amenable candidate for community control, and because we do not have a joint recommendation for 8 months anymore, the state is recommending a prison sanction that is higher than 8 months at this time. Thank you.
This court reviewed the pre-sentence report and investigation. I've considered the facts and circumstances of the offense involved, the nature of the offense involved. I consider what's been said here today by Mr. Matthews. The prosecutor, I afforded the defendant an opportunity to address the court. He chose not to make a statement, which is fine. He doesn't have to do that. All this is considered in light of the purposes and principles of felony sentencing set forth in 29-2911 of the revised code. For the factors in 29-2912, the court finds that the defendant's conduct or in the nature of this offense was a part of organized criminal activity. The woman he was with that day was printing out these fake licenses with his picture on them, several different names, at least 6 or so names, that they would then use these licenses to do returns, fraudulent returns at stores. The organized criminal activity makes it more serious. Nothing makes it less serious. As for recidivism factors, the court finds the defendant has many of these factors present. He's got a lengthy criminal history, which includes significant juvenile delinquency adjudications when he was a minor, which he was committed to the Department of Youth Services, and then that kind of continued as an adult. He served an 8-year prison term in Cuyahoga County for engaging in a pattern of corrupt activity along with other aggravated burglary, along with other felony offenses. Upon release from prison, he was on post-release control, violated that, was sent back to prison for an additional, looks like 9 months. Just released September of 2025. This offense was committed 4 months later. So he's not responded favorably to previously imposed sanctions. He was on post-release control at the time he committed the offense. No factors indicate recidivism is less likely. Under 2929-13B1, the defendant previously served a prison term. Prison is consistent with the purposes and principles of sentencing, and also that he was on PRC is another factor under 2929-13B1. Prison is consistent with the purposes and principles of sentencing, and the defendant's not amenable to any available community control sanctions. Therefore, it will be the sentence of this court that on count 1, the defendant served a term in prison of 11 months. He has credit for 110 days he's already served. Count 2 will be dismissed as agreed upon. Need to advise you upon your release from prison. In this case, you will be placed on post-release control for up to 2 years. If you are and you violate any of those conditions, the parole authority could send you back to prison as punishment for violating the rules for another 5.5 months, the maximum being 50% of what I just imposed. Any additional prison term imposed for violating post-release control is being imposed as a part of the sentence at this time. The court disapproves the defendant's placement in a program of shock incarceration, intensive prison program, or transfer to transitional control. And the defendant's ordered to pay off costs in this action. Is there anything else for the record, Ms. Wood?
No, Your Honor, thank you.
Mr. Matthews?
No, Your Honor, thank you.
All rise.
Ms. Linden?
Thank you, Your Honor. Your Honor, we're hearing case caption State of Ohio versus Michelle Fialco, case number 26CR000307. Excuse me, we were last here on April 27th, at which time the defendant entered a written and oral plea of guilty to one count of aggravated possession of drugs, felony of the 5th degree in violation of revised code section 292511, with an accompanying forfeiture specification pursuant to 2941.1417 and 2981.04. The case was then referred for pre-sentence report and investigation and drug and alcohol evaluation. Those have been completed, and we are here today for purposes of sentencing. Defendant is present today with her attorney, Mr. Chad Mulkey.
Mr. Mulkey, any reason not to go forward with sentencing?
No, Your Honor.
Is there anything you'd like to say on behalf of your client?
There is indeed, Judge.
Go ahead.
I've conferenced with my client, and she is 44 years old. She has struggled with addiction, specifically to methamphetamine, for a long time now, and her criminal history bears that out. Her treatment history bears that out. And I know there was some discussion in Chambers about her wanting outpatient treatment. She's got some jobs waiting for her. However, when I reapproached the subject of NeoCap with her, she seemed very much interested in doing inpatient treatment rather than outpatient treatment. So I think that is the route that she would like to go, and that she really does want to get help. And I know the presumption in favor of community control is overcome, and that her history would bear out the fact that she would not be amenable to available community control sanctions. However, she would ask this court for another chance to get things in order in her life, and do that by way of inpatient treatment, Judge, rather than prison. Thank you.
Thank you. Ms. Fialco, you have the right to address this court before your sentence. You can say anything you'd like. Is there anything you want to say at this time?
Yes, Your Honor.
Good.
I just first and foremost want to start by taking accountability for my actions. And I'm sorry for breaking the law by the choices that I've made. Having this time to sit, I've realized how it's affected my family, my kids, my life. I do have a job, however, and I just got made another offer for another job by somebody I met by going through AA and NA meetings with. And I would like the opportunity to continue that too. And I would like treatment so I can get help for my addiction, Your Honor.
Anything else you want to say?
No, thank you.
Schmolke, anything else on behalf of the defendant?
No, thank you, Your Honor.
Ms. Linden for the State of Ohio.
Thank you, Your Honor. Your Honor, as indicated in Chambers, the state submits that the defendant is not amenable to community control sanctions, and we're asking for a prison term. Looking at her prior history, her history goes back to 2008. She has, as Mr. Mulkey said, the presumption for community control is overcome by her prior prisons, but on those prior prisons, except for this very last one, she's given all kinds of opportunities, and she had multiple probation violations. I just don't see, with all the treatment that the court has already given her, that at this point in time that is something that she'll follow through with. So she does have 95 days of credit for time served. I know she also, although on traffic offenses, she has some outstanding warrants there too, but we would ask that you have the forfeiture specification, that all those be forfeited, that she be given time in prison and 95 days of credit for time served. Thank you.
Thank you. Well, I've considered the pre-sentence report investigation that was completed in this matter. Drug and alcohol evaluation. I've considered facts and circumstances of the underlying offense, the nature of that offense. I've considered what's been said here in court today by Mr. Mulkey on behalf of his client, the defendant, the prosecutor, the recommendations. All this is considered by the court in light of the purposes and principles of felony sentencing set forth in 292911 of the revised code. As for the factors in 29, 29, 12, factors indicating the conduct is more or less serious. Nothing's present in this case making it any more or less serious than what normally constitutes the commission of this offense. However, for the recidivism factors, almost all of these factors are present, indicating recidivism is more likely. She has a lengthy history of criminal convictions. It goes back, 18 years? She's been in front of this court, I think, at least 4 occasions. This is her 5th time. I put her on probation. The first 3 times she was put on probation in this court. Every time she was on probation, she violated her probation. The last 2 times she was on probation in this court, she ultimately went to prison because of her continued violations. The last time, she just went right to prison. There's obviously a drug abuse problem that relates to the offense, and I don't think she either understands or recognizes the extent of it or really wants treatment. All along she wanted outpatient treatment until today, right before I walk out here, and she's advised that that's not going to happen, and all of a sudden now she wants inpatient treatment. According to her lawyer, she didn't say that. She said she wants to get to work. But if she truly recognized the extent of her problem, 1, she can get treatment on her own. You've never sought treatment on your own. You always come in here saying, I want treatment. But you don't have to commit a felony to get treatment. You can get treatment on your own.
Going to meetings, sir.
But you don't do that. Two, I've given you everything we have. You've been in multiple treatment facilities, and every time you're here, it's the same exact story I hear. Same exact story. And I'm not going to continue doing this. I don't know how I can find you're amenable to community control sanctions, because you've been on community control sanctions in this court. And you violated every single time you've been on community control sanctions in this court. There's no factors indicating recidivism is less likely. Under 29-29-13B1, defendants previously served a prison term, so that overrides any presumption for probation, permits the court to impose a prison sentence. Prison certainly is consistent with the purposes and principles of sentencing. And again, to put you on probation, I have to find you're amenable to probation. And I don't know how I can make that finding, because you're not. It's the same song and dance every time we're here. And this is how it's just going to continue. So if you truly want help, get help. I don't think you will. I think you'll wait to get in trouble again and come back and say you really want help. But I'm not going to continue doing this because you're not amenable. Therefore, it's the sentence of this court that on count 1, defendant served a term in prison of 9 months. She has credit for 95 days she's already served. Need to advise you upon your release from prison. Could be placed on post-release control for up to 2 years. If you violate any of the conditions of your post-release control, the parole authority can send you back to prison as punishment for violating the rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half, which would be 4.5 months is the maximum. Any additional prison term imposed for violating post-release control is being imposed as part of the sentence at this time. Court disapproves the defendant's placement in a program of shock incarceration, intensive prison program, or transfer to transitional control. Defendant's ordered to pay off costs. I'll order the forfeiture of the contraband and instrumentalities. I think that's everything.